5 seconds to go. Start. Same shall be registered under and in accordance with the provisions of and with the authorities prescribed under the Registration Act. However, the fee to be paid for such registration has been specified by the provision of Section 4 itself. Hence, it is clear that while subsection 1 of Section 4 overrides Section 107 of the Transfer of Property Act, subsection 2 is enacted in the nature of overriding the provisions of the Registration Act 1908 except to the extent of same being saved by the language of this very subsection, that is, regarding the authorities with which and the manner in which it is to be registered, the compulsory registrability and the form of the rent agreement is not arising from Section 17 of the Registration Act. Rather, the registrability, the format of agreement and the fee payable for such registration are referable exclusively to Section 4 of Punjab Rent Act and not Section 17 or any other provision of the Registration Act. Any other interpretation would render the non-obstant clause used against registration as nugatory. Hence, even the word underused in Section 4 has to be read as relating to formalities and requirement to be completed for undergoing the procedure of registration under the Registration Act. Therefore, registration of rent agreement is referable to Section 4 of the Punjab Rent Act and not to the provision of Section 17 of the Registration Act. The second aspect of this provision is that it does not create any consequences for non-registration of a rent agreement entered into between the parties under the Act. In the Punjab Rent Act, there is no other provision also prescribing any consequences for non-registration of rent agreement. Therefore, this provision as contained in Section 4.2 of the Act is only directory in nature. Once an agreement is in writing as is contemplated under subsection 1 of Section 4, it becomes a valid agreement. Mere non-registration of this agreement does not divest it of its essential character and nature, since the provision as contained in subsection 2 requires registration and procedure thereof, and no further consequences are provided for it. This registration can be interpreted to be only by way of ensuring that the public authorities are having the record of the rent agreements and the scope of disputes between the parties to the agreements is narrowed down, but non-registration of the agreements as such would not make the agreements to be void. Issue number 5, as found above, since Section 4.2 is enacted with a non-obstant clause the provision of the Registration Act except to the extent the same are saved by this very subsection stand excluded. Section 49 of the Registration Act 1908 is not saved by this section. Stop.